this Thursday afternoon, January 22nd. And we're going to get a walkthrough of, I don't know if I would at this point call it a palate cleanser type bill, because we're not done with the main courses somehow. I'm looking for this metaphor here. Help me out with this, Eric. Is this a palate cleanser, you think? Is it?
That's the next thing.
Yeah, no.
All
Right. Yeah, H589. It's a short bill, but an important.
It is short, I can confirm that.
And we're going to have a walkthrough of the concept and the language. So, Eric, thank you for being here.
Yes, absolutely. Good afternoon, everybody. Eric Fitzpatrick with the Office of Legislative Counsel, here to do a walkthrough with the committee of House Bill number 589. It's an act relating to a 6-year statute of repose for actions arising out of improvements to real property. So the subject here, statutes of repose, might not be quite as familiar a term to everybody as it's closely aligned relative the statute of limitations. So it's a very, very similar idea. So it has to do with the idea that, and I understand from Michelle that you guys were talking a little bit about statute of limitations this morning and a different type of lawsuit, voyeurism, perhaps, if I remember right. So you were talking about the idea a little bit. But to refresh your recollection and let you know how statutes of repose are a little bit different than statutes of limitation. A statute of limitation sets a time period within which a lawsuit may be brought. If someone's injured, say, then they have a specific period of time within which you can bring a lawsuit to try and get damages for that injury. Excuse me. Now, and I can't remember. I don't know. I didn't look at the testimony from this morning, so you may have talked about this. But if you think about a time limit, and statutes of repose also have to do with time limits within which lawsuits have to be brought. And if they're not brought within these time limits, they're barred. They cannot be brought. Court will say, sorry, you missed the time limit. That's the hard and fast rule. Case dismissed. You can't bring your suit. And as you can sort of tell from the first word of statutes of limitation and statutes of repose, who sets these time limits? You do. They're legislatively set. So they're policy decisions about how long you think. And of course, there may be some constitutional limitations on the outside, but for the most part, they're legislative determinations. So as you may recall from the statutes of limitations idea, if you think about it in any context, however long you have to bring your suit really depends. It's really important when the clock starts, right? What's day one? If you're going to be counting 3 years, 6 years, 10 years, whatever, well, when do I start the count? And that's where the distinction lies between statutes of limitations and statutes of repose. The limitations period, you may remember this word, that period starts counting when the cause of action, when the lawsuit accrues. That's the word, whenever the lawsuit accrues. So just as an example, and I sent this to Nate, so you'll have this on your webpage when you want to look at it. But for example, there are dozens of statutes of limitations on the books right now for dozens of different, it all depends what kind of action. Is it medical malpractice? Is it a skiing injury? Is it something related to trespass upon land? All kinds of, you looked at this morning, voyeurism, I think that was criminal and civil. But they can be set and are set legislatively, but there also are a couple of catch-alls, that set limitations. Not every of all the hundreds of different kinds of actions there might be, they don't all have their own statute of limitations statute. So you have these catch-alls, and those happen to be, a catch-all for civil actions and a catch-all for personal injury actions, broadly speaking. So what are they? Just so you know, that for personal injury actions, the one we'll kind of talk about today, and then personal injury includes property. So any damage to the person or property, your statute of limitations period is 3 years, generally speaking. It's got a 3-year limitations period. Again, when does that 3 years clock start ticking? Starts ticking when the cause of action accrues. And that one in particular, that sort of refers to that in the statute, the language kind of refers to the idea. Cause of action shall be deemed to accrue, and this is in 12 VSA 512, as of the date of the discovery of the injury. So generally speaking, accrual, when a cause of action accrues, that means when it sort of vests in the person, right? Arises, it comes into existence. And when it comes into existence or vest, that's when tick, 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 that clock starts ticking, whether it's 3 years, 6 years, whatever it is, whatever you as a legislature decide it should be. So as we said, that clock starts ticking when the cause of action accrues to the person. And generally speaking, for civil actions, it accrues as of the time that the person who's injured or suffers the injury either discovers or reasonably should have discovered this injury, that they had the right to sue, right? So in other words, it's not necessarily or isn't actually the date of the conduct that caused them to suffer this injury. It could be exactly the same. I don't know if you're in a car accident and you were injured right then. Well, chances are you discovered it at the exact same moment that you had the injury. But it doesn't always happen that way. Sometimes those two things might be different. As an example, which is hopefully relevant to H589, an example, let's say you hired somebody to do some work on your roof in your house. And unbeknownst to you, there was faulty work done on the roof, and there was a leak that was going on into the rafters, didn't leak through the ceiling, so you didn't see it. But it was coming through for a long period of time. You never knew about it. And again, hypotheticals, we're just kind of using them to kind of illustrate things. So it's not being a construction expert, this might not happen exactly this way. But let's assume for the sake of understanding how this statute of repose period works. Think about it, show you how the difference is. So, and you were walking right under the roof, under the ceiling rather, collapses, you get injured, right? So when did you discover it? And when it hit you. But possibly, when did the cause of action accrue? That's potentially true. And that's the difference between the statute of repose and the statute of limitations. The limitations period, you're right. Cause of action accrues when you got hit, because that's when you discovered it. And you didn't have any way of knowing before that, right? Through the exercise of reasonable discretion, you didn't know about the leak. You didn't know it was leaking into above the ceiling. It was happening all that time, but you didn't know. What the statute of repose says that's different is that clock doesn't start ticking when it accrues. Doesn't start ticking when you discover it or you should have discovered it. That clock starts ticking. Look at the language of H589, line 20. Well, it's in two different places. Start at line 17. Oh, no, sorry, I was right. Line 20. The action shall be brought within 6 years, see that on line 20, after substantial completion of the improvement. So the clock doesn't start ticking when you say we're walking on that spot in the ceiling and you got hit. That's when you discovered it. In this case, the clock starts ticking 6 years after the completion of the improvement. In other words, the work that was done that caused the leak. So so this is 6 years though. And remember what I said about the statute of limitations period, that's 3 years. So it will not coincide necessarily, the statute of limitations period and the statute of repose period. And this is longer. So it gives you more time. You only would have had 3 years. I suppose it depends when the discovery would have happened. It could be shorter as well. That's the whole idea. If you would say the work had been done last year, a year ago, and a year later is when you have the injury, well, then you have 3 years from then, right, to bring the lawsuit. And in that case, you would have had 6 years from the date of the work, so the statute of repose period is longer. See that? The way that sort of math works out. But if, on the other hand, the work had been done a year ago and the injury didn't happen until, I don't know, say 7 years after that, then even though you hadn't discovered it yet, couldn't bring the lawsuit because it's a 6 year sort of finality date, statute of repose. So it's almost like an end date. It is like an end date, regardless of when you discovered the injury. Discovery doesn't matter as far as when the clock starts ticking. It's when the work was done that starts the clock. And in some ways, sometimes it can give you more time than the limitations period would give you, and sometimes it can give you less time, depending on the facts of when it all happened. So that's the difference of the statute of repose. It really turns on, and this is just something I pulled out of Black's Law Dictionary. It's sort of trying to describe the distinction. statute of repose bars a cause of action after a period of time running from a particular act or event, even if the cause of action has not yet accrued. And it gives an example, interestingly, related to construction work. The statute of repose began to run upon completion of the house, even though the defect was not discovered for several years. Because it's when the discovery is made that the statute of limitations clock starts ticking, but it's when the work was done that the statute of repose clock started ticking. And that's the distinction between the two things. And what H 589 proposes to do, as I was just kind of mentioning, is to create a 6-year statute of repose specifically for particular types of actions. In other words, it's not for all civil actions. It's for actions arising out of improvements to real property. So if you look at the language for a moment, and that's the title of the proposed new section, action arising out of improvements to real property, statute of repose. The provision is that the civil action for personal injury or property damages that arises out of a deficiency in the creation of an improvement to real property. So that's where the flaw is. Could be design, planning, contract administration, supervision, or construction of the improvement. Shall be brought within 6 years after substantial completion of the improvement. Doesn't matter when you discover it. It's a clock that's connected to the design, construction, whatever the work was that was done that substantially completed the improvement.
Do you know how they came up with the number here?
You know, I will say that there are a number of states that have this statute in law specifically related to construction improvements. They have statute of repose, and the number of years varies. And so some of them have 6, some are 7, some are 10, some are 3. So I don't know how the 6. I think it was a proposal from the sponsor, the legislative sponsor. So that's a witness or the legislative sponsor might be able to answer that question. But I think it's within the range of what you see in other statutes. Put it that way.
Well, I have another question relative to what other states might have. So the types of civil actions, personal injury or property damages, is that fairly common, or could there be other types of actions? Could there be fewer actions if it was like only property damage, for instance, or is this follow what other states do?
I think in terms of the types of actions to which it applies, it seems fairly similar. But I think you're right if kind of what you're saying is it could be crafted differently to apply only, say, to personal injuries or property damage, or maybe I'm misunderstanding.
And no, that's why I was just wondering what other states did with respect to that. So.
Right. Yep. Well, I thought it was some of both, but and I also sent to Nate for posting. There's a several years old, but still a list of other state statutes in this subject area, and it's lengthy. And there's a lot of details in how they may differ with each other. Like some of them have exceptions. Some of them, and as does this, by the way, I haven't got to the fraudulent conduct exception, but I think it varies so much. I was finding it hard to say there's some general way that it's done. It seems that's a lot of different ways that it's done.
But when's the last time this bill was before us? Because you said that.
That sounds about right.
Yeah.
It has been introduced before.
I don't think we took it out.
It's been on the wall.
On the wall.
Yeah.
It's been a while.
Right.
Okay, yeah, go ahead.
So yeah, I mentioned that there's an exception, which is common for statutes of limitations generally. Subsection B, page 2, you say this doesn't, the language says the section doesn't apply if the action involves fraudulent misrepresentations or actions involving the fraudulent concealment of material facts upon which a claim is based. In other words, you can't, hide the fact that there was this design flaw, this construction flaw, or whatever it might be, and then take advantage of the fact that the statute of repose clock is ticking. If you do that, then the statute of repose period doesn't apply. And the general rule, which is that a statute of limitations is told when there's fraudulent concealment, would apply. So they still have time. As long as the fraud was being perpetrated flaw was being hidden, the clock is not ticking.
Yeah, go ahead, Ange.
In that case, Eric, would the clock start with the discovery?
Typically, yes. Yep.
It would work. Alongside a warranty, concurrently.
In other words, an action for breach of warranty, you mean? Like,
Yeah, suppose some, the work with warranty,
yep.
and then something happened within that warranty, but yet there might be a dispute there.
Mhm,
But
mhm.
until that is resolved, and then does it start, concurrently with the warranty that's issued?
I would say that in terms of when it starts, it's probably the issuance and signing of the warranty by the parties. But it's an interesting question of,
Well, the warranty, the deal wouldn't be complete on the transaction, I
Right.
would assume.
right, exactly. But a breach of contract action, which that might be, is often covered by a different statute of limitations period than a personal injury or injury to property action. In this case, though, where it all sort of arose out of, say, a faulty roof or whatever it was, then I'm not sure if the underlying limitations period would be the same, whether it would be because the action for breach of contract is typically 6 year statute of limitations period, as opposed to the 3 year one for personal injury or damage to property. So that part's an interesting question. It may not have that much of an impact because the statute of repose would apply generally 6 year period. It turns upon sort of the damage to the property, the faulty ceiling, the faulty roof, whatever it might be. But I think it would coincide, at least it would start at the same time that the breach of warranty period started as well. But I haven't had that, I've thought about that deeply, so I might want to think about it a little more. Yeah, no, it's a good question.
Barbara has a question. Well,
So Eric, I'm wondering how, like, climate change and affects this issue. Like, for example, with us seeing 100-year floods more frequently or different temperatures, like things that are like maybe building was constructed for normal Vermont conditions, but for normal Vermont conditions aren't what they were, even in a few year period. So I'm wondering if it's more not just the building itself, but like environmental changes that maybe the building should have been built to withstand flooding. So maybe it would have had a different drainage system or whatever. How does that kind of thing factor in when it's not just the building?
I don't think it factors into this bill.
Okay.
I think what you're talking about could conceivably factor in to the standard of care involving the building in the first place. In other words, perhaps the standard of care, how a building should be constructed could conceivably change over time with the changing circumstances of whether it's climate change or flooding or whatever it may be. Like the standard of care, for example, say in the Mississippi Delta that floods all the time might be different than the one that is here in Vermont. Yes.
Like an earthquake.
Right. But that doesn't have anything to do with the statute of limitations. That has to do with whether or not it would have been negligently built in the first place. So it's not about the clock ticking. It's more
So
about
if the roof failed because the flooding was so severe that these 30-year shingles, let's say, really couldn't withstand the amount, 30 years of rain came down in a week or so. So it might be more subtle even.
yeah, as I said, I don't think it's connected to this.
Okay, all right.
I think that question is a question of whether or not the construction was proper in the first place, given the circumstances. What's that?
It'd be like a code issue or something.
It could be code, because that could be something that was, but it could also be the standard of care in light of all the circumstances. But that doesn't have to do with when the clock starts ticking for the limitations period.
Right.
Yep.
all right, go ahead.
That's really most of it, other than the definition of substantial completion, which you see in subsection C, page 2. That's what does it mean for substantial completion to have been done on a project? It means that construction is sufficiently complete so that an improvement may be utilized by its owner or lawful possessor for the purposes intended. In the case of a phased project with more than one substantial completion date, the 6-year period of limitations, then on a
This don't understand this sentence at all.
That might be just in terms of language, that because this is actually a statute of repose, not a statute of limitations. For consistency, you might want to, regardless of the other issues that you may want to talk about, that language should probably be like repose period or something like that.
6-year repose.
Right. For actions involving systems designed to serve the entire project shall begin at the substantial completion of each phase.
Karen and then Ian.
Yeah, this might be a witness question. But so I understand this, but I guess my question with this is how would these dates be determined or agreed upon? Like, how is it known that the date of this section, you have now hit the what is it called? Substantial completion date for this section. So you know the clock starts ticking.
Right.
Like, how would you know that? Like, would that need to be defined in here, or is that just a known thing, or?
You mean like, sort of looking at the sort of full paragraph? In other words, what does it mean in terms of, or in other words, is it more of a notice question that you're asking? Is it more like, how does the person know when the clock starts ticking? Or is it
Yes.
more, what does substantial completion really mean?
Yeah, well, I think it's probably both, right?
Right.
So say I had a project done on my house and it was this multi-step thing, right?
Yep.
Something goes wrong. And like, how do I know that the clock started ticking 8 years ago for this piece, but it would be longer for this piece? And would I even know that? Would there be any record of that the date is different for different sections? I feel like I wouldn't even know where to go to figure that out.
That's a good question. And it might be one, I think, for your witnesses to start with, but also who would know that? Presumably the person who did the improvements. If your question is like, hey, when did this section get done?
Yeah.
And looking at the language here, and was that designed to serve the entire, that section? Was that part of the whole project? Probably a question for the person or people who did the actual construction. Maybe that would help you and your attorney if you were thinking about suing somebody because of an injury, be able to figure out, well, so does that come under the 6-year period? And should we file our lawsuit now? If I'm thinking about suing, because I don't want to miss the 6-year window and play it safe, right?
Yeah, and is there agreement on, what does it say that is able to be used for the purposes intended? Like, what if I think like, I wanted this to be able to be used for this, and well, we only, so it just seems like there's a lot of vagueness in there that I would want a piece of paper that says, we both agree, this segment is now complete.
Right. Yeah, and maybe there's a way that you could, I certainly, as an individual, you could ask for that with your contractor, but maybe there's language that you could add along the lines of, the parties may agree, something like,
Okay.
What substantial completion includes for purposes of the project, and you know what I mean? So that you're sort of letting people know that they can try and work that out with their contractors, and that way they'd have some sort.
Yeah. Okay. It's helpful just to know that you
Right.
agree that there's room that could clear things up.
Yes, and it may be sometimes the person who ends up clearing these things up is the judge, right? Because it's courts a lot of times that when there's disagreements about whether a statute of limitations has run or not, those can end up in court, and it becomes up to the judge to decide, well, all right, I'm looking at the facts here, and here's when the clock started, and the 6-year period is up, or the 3-year period is up, whatever it may be. And sometimes the result of that is that the court says you're still within the period, you can still file your lawsuit, but other times the result is the clock has already expired and
You
the suit
didn't
is
realize
barred.
it.
Right. Yeah, that does happen.
Ian.
Yeah, I was thinking, we did like the water treatment facility in Brattleboro a couple of years ago, and in the contract there were like set completion dates for. So maybe you could use. But my question, two things. One, I honestly have read this last line like 4 times, and I'm struggling to understand. So okay, in case of a phase project with more than one substantial completion date, the 6-year period of repose involving systems designed to serve the entire project shall begin at the substantial completion of each phase. So does that mean that you're going to get a new 6-year start at each phase completion if it's something that they're working on that benefits the whole project?
That's the way I was reading it.
Okay.
Yeah.
Okay.
But that was my reading. Yes, so you've got 3 different phases of different elements that benefit the entire project. Then substantial completion of phase A, 6-year clock starts. Substantial completion of phase B, 6-year clock starts then. And if they're at different times, then they're going to have different
track of all of it.
endpoints
Yeah.
for those 2 phases.
Okay. And then, okay. Yeah. And then my only other question was, like I was thinking about the bridge below exit 9 on 91 was under construction for like, I don't even know how many years.
Hmm.
And, you drove on 1 lane.
I remember that. Yep.
Yeah. Like, and I'm like, no kidding. Like, I think like 6 years or something, like a really long time. How does that work with the being utilized for the purpose intended? Like, so we are driving over it. It is being used.
So you've only got 1 lane. He means it hasn't been substantially completed.
Yeah.
Wasn't able to pass.
I'm just saying, and I kind of, and I'm not, I guess I'm just, it's kind of a funny thing, but it did come to mind when I was looking at this. And my only other question is, in the states, the other states, I guess most states have a statute of repose.
For this type of thing.
Yeah.
Yeah, it seems that.
Is there, in any of them that you were looking at, did any of them have a carve out for like massive projects? Like an amount of damage, or I'm thinking about like if we're using the bridge example, like a catastrophic bridge collapse that happens outside of the 6-year statute of repose or period of repose, and it does actually come to light that it was from negligence in the construction. Is there any carve out?
I honestly didn't look at every single one of the other state ones. I did not, right. But another interesting question. I have to happy to do that. So I don't know whether nothing leapt out at me, but I wasn't looking for that either.
Yeah, and maybe it's not really something that is done.
Right. I don't know. It might be. I don't know. I'll check.
Cool. All right. Those.
Ken,
Can I? Trying to understand your bridge
I don't know. It's just
thing at the beginning. What about for how long you were, what was the point you were trying to make?
fair. So the substantial completion in section C of this says a section, it's considered substantially complete, meaning the clock is starting to run on the repose period if it's substantially complete, and it is defined as substantially complete if the improvement may be utilized by its owner or lawful possessor for the purpose intended. And so in this like really long bridge project on 91, I drove over it all the time, and it was really annoying. So
Why did you go around?
well, I could. I meant more that there was construction being done on it the whole time.
No, I get it.
Okay.
That's a pretty big pass, but go ahead.
So it was, I think, maybe considered substantially complete because it was being utilized for
One lane.
purpose. One lane. I don't know. Maybe there's some way that it's not substantially complete because the 1 lane's open. But I was just sort of curious, how does that work with when this clock starts ticking because it's being utilized for its purpose?
Yeah, I understand. Okay, thanks.
And if I may, I feel like it connects back to my
Okay.
question of there needs to be agreement or a clear line of like, we know we've met this
Sure.
substantial completion.
Yeah. I'm sure we'll get an
Yeah.
answer. Yeah.
It is true that with statute of limitations as well, though, that, when you talk about, say, there isn't a discovery rule here within this, so it's the same language with the idea that, when a reasonable person exercising, reasonable judgment should have discovered something, is not something you're going to be able to legislate with clarity from here that will cover every individual circumstances forever. So I guess the only point I'm making is that, yes, obviously want the language to be as tight and cover as many things as you can, but it probably won't be able to anticipate every single way that things might unfold. So those things may end up being litigated in court potentially.
Or we just let it sit.
All are your policy options.
There's some witnesses as far as the need, and then some witnesses who will probably argue there is no need, and then we can decide.
I'm just putting out another option.
Oh, yeah, the other option is, yeah, that's. But no, we'll hear some witnesses because we have 3 tomorrow morning.
I'm very open to this conversation.
Any other questions for Eric?
Thank you.
Sure, happy to help. I was all ready for one question that didn't come.
Ask the questions yourself.
All right.
Make us feel bad for not.
Yeah, council, do we have any other statutes of repose?
I was gonna ask that, Bill.
You are?
I was about to ask that.
The answer is, as far as I can tell, not many, but there are some. And I like my search of the statutes just for the word repose only came up with one, but it doesn't always necessarily call the statute repose. I think it really has more to do with how it works.
Yeah.
It's not really based on the discovery. It's more about start at some period of time and then the clock starts ticking. So the one I found that I think is a period of repose happens to be about actions brought in the context of unclaimed property by the administrator of unclaimed property. There's a statute of repose for how much time the administrator has to bring an action to enforce the unclaimed property statutes. Interesting. And another one, I believe it's not 100% clear, but I think it is a statute of repose, is within the medical malpractice statute. And that provides that, and it's 12 VSA 521. Another thing that I sent to you and that you will find posted on your links there is, this is posted, it's really this entirety of the chapter in Title 12, Chapter 23, which has all the statute of limitations. And just so you can look and see, wow, there's individual statute of limitations for all these different kinds of actions. But remember I said there's general ones for civil and actions generally as well. But there is one for medical malpractice specifically. And that one is within that chapter. And that language says that if it's an injury that you're bringing to recover damages for injuries to the person, so it's personal injury, arising out of any medical or surgical treatment or operation, shall be brought within 3 years of the date of the incident, or 2 years from the date, from the date the injury is or reasonably should have been discovered, right? So there's your discovery rule. That's more the limitations period kind of thing, within 2 years from the date that you could have discovered it. So remember, that brings up, I happen to know from talking to Michelle, one of the she mentioned an example this morning. That's like, and in fact, it's even specifically referenced to the statute. It tells you for a period of time, the discovery of a foreign object in your body after surgery happens to be a whole class of type of lawsuits. Yes, exactly. That's not making anything up. That's like a whole genre.
That's an exemption.
Yes, well, yes. So there's something specific about that in there.
So you have to discover within 3 years whether they got the glove inside.
With respect to the discovery that you get it's told until you discover. Yeah, so you get 2 years from the date you discover it. So no, you're not. It doesn't count against you not to have found it yet.
Isn't it more statute of limitations than repose?
Yes, I haven't got to the repose thing.
Oh, I'm sorry.
Yeah.
All right. Well,
But the rest of it.
I'm glad I could identify.
Yes, that's right. Right. But that is more of a statute of limitations thing, because in that case, you have until the discovery before the clock starts ticking. But the rest of that sentence, whichever occurs later, but then it says, but not later than 7 years from the date of the incident. So that's a repose period. That's saying, hey, in that case, so now I haven't looked at any of the cases to it because, all right, if the courts tried to carve anything out of that, I don't really know. But the way it's written is definitely a repose. 7 years, again, not based on discovery at all. It's from the date of the incident that clock starts ticking.
You talking about carving out the instrument that's left with somebody?
No, that one is an exception. That one you get.
Play on words.
Does that one?
Oh, right.
Does that have to? Does that discovery one still have to happen within the 7 though?
I'd say no,
Oh, interesting.
because that's a separate sentence. I would read that as an exception to that.
Oh, wow.
but
Huh.
perhaps there's been a case on that. Isn't there?
Oh, that's-
Okay.
You know, we can have a little humor in this room once in a while, but remember years ago, the Seinfeld episode where Kramer was up top and he was.
Were you
like-
up?
It was a milk dud or
It was,
something like.
it was.
Junior mint.
Yeah, yes.
Reference to it.
Right?
It was.
And he goes and the, whoops.
Right.
Like this, she's just.
The junior mint statute of limitations.
We could flick one of those off that bridge we're talking.
All right, well,
Funny that I milk dud.
Thanks for bringing all that stuff up.
so we'll put Nate on finding that video for us to watch.
Oh, yeah.
Tomorrow morning, we have 3 witnesses on this bill, right after the floor. We'll see how long the floor lasts and whether we can get to them all. And then we do have, some testimony in the afternoon. We have, we're wrapping up, at least for this stage, the victims' rights in forensic system. And then we're gonna have Matt Valerio in on this bill, no, not this bill, on 626, as well as the, victims' bill. So, be prepared to come back for, well, I have it scheduled to end at 3. And we'll hopefully end